Today's presentation is brought to you by the Business Law section of the Florida Bar. This presentation will be part of our COVID series. We have had 2 in this series so far, and we still have a few that will be taking place over the next couple of weeks. The live presentations for all of our CLEs in this series will be free to all of our registrants, and we encourage you to register for all of the upcoming CLEs that we have available. The products will also be available for aftermarket viewing on our section website. It does take a day or 2 to get those recordings uploaded, so please note that it may be a day or so if you want to watch this one again. We also encourage, if there's anyone that was not able to make it to the live event today, we encourage you to let them know that this will be available on our website and they're more than welcome to view it at their leisure. The information, we also have other information on our website. We have a COVID page, and that page is available to everyone. It just has all different updates that are happening right now with anything that is COVID related. If you have any questions about any of those events or anything that is on our COVID page, please do not hesitate to reach out to me. My information is on there as well. Now, the CLE that we're presenting today is going to be 1 hour, and there is a question and answer at the bottom of your page. There's a question and answer box, and we ask that any questions that you have be fielded through there. Our presentation will be moderated today by Allison Leonard and Keith Bell. And Allison, I'm going to go ahead and turn that over to you now, and thank you for joining us.
Thank you. Good afternoon, everyone. Thank you to the attendees for logging in this afternoon, and to Judge Hansman and Judge Thomas for taking the time to meet with us for our discussion on virtual practice in business court. So when the news of the COVID-19 pandemic spread and the courts were closed to the public, the 11th Judicial Circuit moved pretty swiftly to implement a foundation for virtual practice to ensure that the courts were operating to the fullest extent possible, consistent with public safety. So many divisions began holding motion calendar virtually and conducting other virtual proceedings. And while many of us have attended discussions between the bench and the bar concerning the mechanics of and the logistics of virtual practice, cases in the complex business litigation division are by their nature complex, and they present unique challenges in a virtual setting. There are typically many more parties involved in the cases, higher volumes of documents at issue, and larger amounts of money at stake. Judge Michael Hansman and Judge William Thomas both sit in the complex business litigation division of the 11th Judicial Circuit in Miami-Dade County. Both of them were early adopters of the technology being implemented for virtual practice during this time. So we're going to hear from them this afternoon about what they in particular are doing in their divisions and how they're handling some of the issues concerning virtual practice that have come up as we move into the second month of virtual practice in business court. So Keith and I prepared some discussion questions, and we'll be taking questions from the audience at the end. Why don't you go ahead, Keith, and ask the first question?
Sure. Thanks, Allison, and thank you, judges, for your time today. I'd like to begin, judges, by asking about your general experience with the Zoom platform. Has it met your expectations? Has it been better than expected? Please, Judge Hansman, you first. Give us a general description of your experience over the past month or so with this technology.
Okay. Well, first of all, thank you all for being here and for inviting me to attend. It's a pleasure to be with you guys today. You know, we started the Zoom platform shortly after having to leave the courthouse, and I have found it to be remarkably efficient. I may never go back to the courtroom, so I'm joking, but it's you know, there are some cons to it, but overall, it's been very effective. There are some things that are a little bit more difficult to navigate, particularly when you have multi-party hearings. And you know, there are some things that you have to do a bit differently because you don't have the ability to connect with lawyers. People can't hand you documents, and it's not as free-flowing as it would typically be in a courtroom. You know, you have to be much more careful about moderating the conversation because when people talk over one another on Zoom, it can get a little bit difficult. But overall, it has allowed us to keep cases moving. I've handled a number of emergency hearings, injunction motions on Zoom. I've had a couple evidentiary hearings, And it has basically provided a great stopgap to enable us to keep cases moving, keep litigants from languishing and not having their cases heard. And I have found it to be fairly effective. I have not hosted the meetings. I typically allow the lawyers to do that. And most of the lawyers that practice in this division have very sophisticated technology people and equipment and are able to host the meetings. I've had a little bit of difficulty. I have one or two cases with a pro se litigant. I won't mention the name because Will donated those cases to me. And there are 4 writ of prohibitions pending now, so I need to be very careful. But I've had some difficulty with pro se litigants and other people that may not have as much technological advancement. But other than that, it's gone pretty well. I think the lawyers enjoy it. It saves people a lot of travel time, parking, waiting around. It can be very, very efficient way to handle matters.
Thank you, Judge. And we are going to get into more detail about presentation of evidence and witnesses and things of that nature. So I'm happy to hear that you have had evidentiary hearings. Judge Thomas, on that question, your general view of how the Zoom process has gone, is it consistent with Judge Hansman's assessment?
Not sure if you all are hearing me.
Yeah, we can hear you, Will.
Well, we could, but now I believe you're muted.
Okay, I can hear you now. I apologize.
There you go. Yeah, you're fine now.
All right. First of all, let me say that, again, I think this is a great forum, and I appreciate the opportunity, along with Michael, to share our insights on this particular topic. It feels good to kind of be back at work, and this is the best, I guess, that we can do. And so the platform has given us an opportunity to start actively litigating again. And I think the lawyers appreciate it, and I also have appreciated it. I'm still adjusting to Zoom because I'm more of an in-person type of judge. I like to be able to have people in front of me where I can assess their demeanor and just get, almost like the vibe. Do I need to ask some more questions? And I'm not sure I get that same opportunity through the Zoom platform. But we've had quite a few hearings, including, as Michael has indicated, evidentiary hearings, and they've gone very well. I think that everybody's being incredibly professional. I'm assuming later we're going to talk about some of the hiccups that we have all encountered in using the platform, but I have found the platform to be overall a good experience. And I'm not sure lawyers are going to ultimately want to go back to in-person hearings because I believe it probably saves them a lot of travel time. It saves them a lot of clients can be present on the calls and hear everything that's happening without inconvenience. So there's so many benefits to Zoom, and we got to work on a couple of the challenges, but overall it's been a positive experience.
Great. And Judge Hansman, you mentioned that you had not been responsible for actually hosting the meetings as of yet. Is the Zoom platform the required video conferencing platform in your court, or is it just the platform that has been used by everyone thus far?
My understanding is it's required. The court has contracted with Zoom to be our provider. And my understanding is our administrative orders require that the hearings be by Zoom. But Keith, frankly, I've never had anybody try to host a hearing on a different platform. I know some of my friends in the business world are using Microsoft. There's a Microsoft platform that's fairly popular. But I have not had anybody try to host a hearing by way of another platform. It's just been Zoom hearings since we started.
I can appreciate that. I feel like I've lived in a Zoom room for a few weeks now. So, Judge Thomas, one last question on the broad discussion of the Zoom platform. You indicated that there have been some technical difficulties. Can you identify a few of the Zoom-specific technical difficulties that you've seen arise on more than one occasion and how those are handled in real time in a courtroom setting?
Well, I'm not sure that there's Zoom technical difficulties. I think that there are more difficulties based upon the users of the platform. For example, when I was logging on to you all, my little one's, he's in school right now. And so he also has to be using Zoom and the same internet connection. And so you saw me freeze up a couple of times. And lawyers have, I think, experienced the same challenges that I've experienced, where I'm talking to you and all of a sudden the lawyer would freeze. And that's because there's multiple people using the same internet connection, and maybe that is causing some type of interference. Also, one of the challenges I think that, that Zoom offers us is that we have a lot of parties that are on the line. And especially in our construction defect cases. And part of the challenge is being able to identify, being able to see all of the individuals, giving everybody an opportunity to weigh in on an issue when they have to weigh in on the issue. Logistically, I think it's a challenge. Not to mention, unlike Michael, I do not host, and I do not allow the lawyers to host the Zoom platform. My assistant host the Zoom platform. And we've discussed how we're going to work that. And I want everybody to be muted. And I want him to be able to unmute people once I identify that that person is about to speak. That's just so that, you know, we don't get people interrupting each other and so forth. The problem with that, of course, is that the court reporter can't be muted, because the court reporter needs to let us know when the court reporter can't hear somebody else in order for purposes of the record. And also, I don't have the ability to mute somebody when it's time where I want to ask a question. I kind of got to let the lawyer say what the lawyer wants to say, even though the lawyer is somewhat, forgive me for saying this because I know some do, rambling. Or I got to say, Andrew, can you please mute the lawyer for a minute, please? And then we go from there. But those are just some of the hiccups. But I'm not sure that the platform has been excellent, by the way. I think it's more the user end of it that has created the challenge.
Understood. Well, that's a good segue to the next topic for Allison to take up, which is setting matters for hearing and conducting hearings.
Thanks, Keith. So in terms of the types of matters that your honors are hearing at this time, what are your general comments on them? I know early on there was some disfavor from some judges as to the types of matters that were being set for hearing during this time. Has that all gone away? Are we free to set whatever matter, you know, litigators wish to set as they would in the normal course, or otherwise?
Well, in my division, I have no restrictions on matters that can be set. I have a non-jury trial that I'm going to try by Zoom next month. I've had a couple injunction hearings, evidentiary matters involving non-compete cases and other types of injunction motions. So I am not placing any limits on the hearings that can be set. I have not at this point experienced a disagreement, though. I have not had, for example, a party object to conducting an evidentiary hearing or a non-jury trial on the Zoom platform. So I have not really had to resolve any disputes and decide whether to insist that parties go forward with a hearing they may feel is not amenable to the Zoom platform. That has not arisen yet. You know, there are some situations that I can envision that would be inappropriate for a Zoom platform. I mean, like I said, if for example there were some dispositive evidentiary issue or a contempt type issue or something, and a party objected to having it litigated by way of Zoom, then of course I would have to cross that bridge at that point. But like I said, so far, everybody's been very amenable, including the parties that are set for my non-jury trial next month. And when I had evidentiary hearings on injunction motions, which required witness testimony and documents and exhibits and the clerk to mark exhibits and those things, nobody objected. So I've really have not had to cross the bridge of, is there some unfairness or prejudice that could arise in forcing a party to litigate an evidentiary matter by Zoom? And that'll be an interesting question if and when I have to cross that bridge. But so far, everybody has wanted to move their cases. and I have not encountered any resistance to handling a hearing on the Zoom platform.
Okay, great. So is it fair to say that there's no matter too small to be set for hearing on Zoom?
No, there's no matter too small. The only thing that obviously can't be said on Zoom is a jury trial. but short of that, everything in my division can be set by Zoom. And like I said, if a party objects, then we'll have to deal with it. But so far, I have not had that circumstance arise.
Great. Thank you. Judge Thomas, what about you?
Well, it's the same. Zoom is the preferred platform, and we are a virtual courtroom. And anything that you can schedule on a normal calendar setting, you can schedule on Zoom. We too have done evidentiary hearings on Zoom, and the beauty of sharing the screen is excellent. Screen sharing is excellent, so the court can see exactly what you can see, and the witness can see exactly what it is that the document that you're referring to. It was surprising to me how well the hearing went. We also are setting non-jury trials, not as quickly as Judge Hansman, but we are also doing non-jury trials, and so I think if you have a matter, you set it on Zoom, short of a trial, a jury trial. We are not doing jury trials because we're not permitted to do jury trials. Plus, I don't know functionally how that can be done. But no matter is too small, except for jury trials, no matter is too big. And we're handling everything on Zoom. And I, too, have not received any objection to any evidentiary matter going forward at this point. But I'm not sure if there's a basis for an objection, because I think right now Zoom platform is the new normal, and we don't know when the establishment of the old system, if it's ever going to be reestablished in the same way, will ever take effect. So Zoom is where we're at.
Okay. So that just leads into my next question, which both of you have pretty much touched upon. Because there are no jury trials, do you find that your calendars are more open for special sets and evidentiary hearings and bench trials? And are you encouraging litigators to go ahead and set their matters now?
Well, can I just say, lawyers have to also be mindful that we have to write our orders. And so we can't have special sets every day, because we still have orders that were pending before all of this happened, and orders that are pending created from some of the hearings that we have. And so we still have to have some time set aside so that we can engage in meaningful thought. Well, at least I do. I'm not as brilliant as Michael Hansman, so he's able to do things that I can't do. So I have to set aside some time so that I can actually do preparation for the hearings. But so what we've decided to do is we're having all morning from 8:30 until 1 o'clock is basically our Zoom hearings. And then from 1 o'clock forward, I'm trying to use that time to do work on any orders that are proposed. So I do encourage lawyers to take advantage of the fact that this opportunity is available and to set as many matters as possible on the calendar. And I do want to say that my goal is to get all the cases ready for trial, so that when we do get back and we're to a point where we can try the cases, it's just an issue of lining the cases up and giving them a date.
Okay, great. So in terms of the mechanics for hearing, we had talked about, Judge Hansman, you said that you prefer for the parties to arrange the Zoom hearing, and Judge Thomas, your judicial assistant, is handling the Zoom hearings. The question, I guess, is for Judge Hansman, because the parties have control. How is it, do you maintain control of the virtual meeting in some way? Are the parties required to designate you as the host?
No, they're not. They're not, Allison. And I'm not a big technology guy. Believe it or not, I still write my orders on a legal pad with a pen. I'm not really adept at the computer. So I would rather just have the parties host, because frankly, it just makes my job easier. I go on a link, there's a notice of hearing. I pop on a link, I'm in the Zoom conference. The lawyers have hosted it without any difficulty. I agree with, some of the only problem I've had is when you're not hosting, obviously you can't mute people, but the lawyers have been really professional. I know it's a little bit rude, but if a lawyer's going on and I can't mute them, I'll just hold up my hand and ask them politely to please stop. And they do. And I'll control it. The way I control it is at the beginning of the hearing, I say, this is how we're going to operate, one lawyer at a time. We're not going to talk over each other. If I need to ask a question or cut you off, I know it may appear rude, but I'm just going to put my hand up. And that's kind of a signal to stop talking because I have a question or I have something I want to interject into the discussion. And lawyers have been very good about that. One of the advantages of this division is that you're dealing with very, generally speaking, you're dealing with very professional, competent counsel that know how to conduct themselves. And I have not had any difficulty by virtue of the fact that I am not personally hosting the meeting. And it's just a habit I got into early, and it was one less thing I had to learn. What Will said too is, what lawyers have to appreciate is there are some things that are more difficult on Zoom, and we can talk about those later, but we do have to enter orders, which is very difficult to do from home because I'm a paper guy. I'm used to having binders. I'm used to having the pleadings. I'm used to having the cases and hard copy in front of me. That's one of the big disadvantages of Zoom hearings, which we can talk about a little bit later. But, it takes more time to write orders. It takes more time to gather materials, have them copied off the computer. There is a little bit of inefficiency by not being able to be in chambers and working with your JA right there that you can hand drafts to and go back and forth. And so we need to leave more time than what I would normally leave for, as Will put it, the order drafting and the contemplation and things of that nature. And so I'm kind of doing the same thing as Judge Thomas. I am I'm dedicating certain times of the day for Zoom hearings. I'm not blocking any weeks. In other words, my trial calendar, now that I have no jury trial calendar, those weeks are freed up to set hearings on. But I'm usually trying to leave blocks of the day, and I think I have the same practice kind of as Judge Thomas. I try to leave my afternoons more available because I think lawyers like to get their hearings done in the morning. I have a motion calendar still, which by the way, I don't do by Zoom. I'm still using Court Call for motion calendar, which is something I may change. The point with motion calendar though is I never have more than a couple. I usually have 2 or 3 cases on motion calendar. It's not like a division where I would walk in and have a 40 case calendar. Usually there's 2 or 3 cases on the motion calendar, and either out of just inertia or whatever you want to call it, I haven't changed that over to Zoom. I've been doing the motion calendar just by Court Call. So I'll leave that. I'll usually do that in the morning, first thing, and then I'll leave that and proceed to the Zoom special set hearings. And I try to get them done by 12, 1 o'clock, somewhere in that area, so I can, work on orders and gather files and do more of my chamber type work in the afternoon. But we're also holding hearings in the afternoon if that's when it accommodates the parties, and we just, we're trying to stay flexible.
Great. Judge Thomas, do you have any comments to that effect? How are you handling motion calendar?
Well, motion calendar, we have it scheduled through my assistant, Andrew, who he loves this stuff. This is what he lives for. So he's right in his element. And the reason why I like having him be the host and I would be the co-host is that we can also set up breakout rooms. And we can, for those individuals who do have kids at home who need a special set time, meaning they can't just get on a motion calendar and wait for 30 minutes for their time to be heard. And they just ask that, well, can you call me? Can you just tell me what time you're going to be calling my hearing? I'm a little sensitive to that because I have a 9-year-old here at home who I know I'm homeschooling. And so I know the challenges associated with it when I'm listening to a hearing and he's bouncing around from one subject to the next. And so that's the other thing I like, that we can have the breakout rooms, we can have the special sets. And it's really been, and it's a great way also, because Andrew and John, my bailiff, this is something that they really enjoy doing. And also we can control the shared screen. There are just different aspects of it. And anybody who knows who's practiced in front of me, I'm one of these control people. I need to kind of have control over what's happening. or at least think I do, because half the time I know I really don't. And so that's why we enjoy doing it. The lawyers have been incredibly professional. Michael is correct. And we've had very few instances, but sometimes the hearings do get a little involved, where people take exception to what somebody else is saying, and sometimes it's hard to kind of claw everybody back. That's the beauty of you being the host, and certain other procedural things that I think help in the process.
Okay, great. So we talked a little bit about logistics of the hearing, and Judge Thomas, you mentioned the court reporter, how you keep the court reporter not on mute, so that you can interject when necessary. What are the other court reporter logistics that you've encountered, or how are you handling the court reporter during these hearings?
Well, really, there aren't really much. One is the court reporter is always able to interject to let us know that he or she is not able to properly take down the record, because if they're not able to take down the record, then the whole purpose of them being there is defeated. Also, initially when we sign on, what I've done is I have Andrew, my judicial assistant, announce the case, the style of the case, the purpose for it being on calendar, and how long the hearing is scheduled for. And that's just to remind everybody you're set for 30 minutes, okay? Because we have another hearing immediately following your hearing. And then when 5 minutes before the 30 minutes is scheduled to expire, I have Andrew announce to everybody, Judge, there's 5 minutes left in the hearing. That way, everybody knows I'm not cutting you off. I'm just, you're aware that I have another hearing. There are other people that are waiting, and we have to move forward. Because as you know, lawyers sometimes think because of the convenience of Zoom that we just have an unlimited amount of time. And I'm not always mindful of the time. And so I'm just trying to resolve the issue, and I may be asking questions, forgetting the fact that it was only set for 30 minutes and somebody else is waiting. And so that's important. And also I have Andrew announce all parties that are present. And by the way, I say all parties. We've had a couple instances where there were reporters that had dialed in and were attending the hearings, and nobody really knew who the party was. And so I kept saying, can you identify yourself? And I guess they could say, no, it's a public courtroom and we want to be present. We haven't had that. A couple of reporters from the Daily Business Review attended a couple of our hearings. And so we just want everybody to know who's on the line, and full disclosure. And we have, non-eventful hearings so far.
Okay, so you brought up an interesting issue, Judge Thomas, about uninvited parties attending hearings or other judicial proceedings, particularly since the Zoom information is included on the hearing notice, which is a public filing. You mentioned some experiences you've had. Judge Hampton, have you had any experience with anyone Zoom bombing, I guess is what they're calling it nowadays, the hearings, and if not, how have you handled it? And if not, how do you plan on handling it?
Well, my cases aren't as interesting as Judge Thomas, so they haven't tried to invade my hearings yet. But I have had a lot of instances where parties and corporate representatives and people that are directly interested in the case kind of appear that aren't counsel, and so you see a lot of these numbers that will typically pop up on the screen. And like sometimes I'll be in the middle of a hearing and a new number will pop in, and I'll have to say, what I'll typically do is at the beginning, I ask everybody who's on the Zoom conference to announce their appearance and tell me if anybody's on who's not counsel. And then the parties will introduce themselves, or the corporate representatives, whoever's there. And sometimes, like I said, I'll be 10 minutes into a hearing and some number will pop onto the screen. And what I'll typically do is just ask whoever it is who's come on to the hearing to identify themselves. They always do. I've never had anybody, kind of just hang around and not tell us who they are. And so I haven't had any real problem with that. But I never really gave thought to the fact that it is a public forum and these Zoom notices are in the record, because when you go on MAP to link onto the Zoom conference, that's a matter of public record. And I guess just like a courtroom, anybody's free to come in. So there's no real way to regulate that, and nor should we, because it's a public forum. And and there's a presumption that anybody who wants to attend has the right to be here. But I haven't had an issue with it. Now, I did have an issue in sequestration, you know, with some evidentiary hearings, but that's the same issue you have in the courtroom, whether somebody should be entitled to be on Zoom while a witness is testifying. And I had to deal with that, just like, but again, it was the exact same issue. It was no different than if somebody had invoked the rule or attempted to invoke the rule in an evidentiary hearing in the courtroom.
All right, great. And that segues perfectly into our next topic area, which is evidentiary hearings and bench trials. Keith, why don't you go ahead and ask the judges about witnesses and exhibits?
Sure, Judge Hansman, following on your last comment, could you maybe give us a brief discussion of practice tips for calling witnesses, and also maybe expound on the logistics for sequestering witnesses, making sure that they aren't listening to proceedings before they're called, and how you've seen the calling of the witness actually play out in your courtroom?
Well, like I said before, the fortunate thing about this division, one of the fortunate things about this division, is you have lawyers who are extremely competent, extremely prepared, and have the resources to take care of the things they need to in advance. In other words, you know, people aren't walking into an evidentiary hearing with a bunch of loose leaf documents and, you know, grabbing them, you know, on the fly. I mean, so what the lawyers have done in the couple of cases I've had is all the exhibits have been placed in binders. There's been copies of the exhibits delivered to me, as well as to the witness. So by the time the witness is sworn in, I'll have exhibits before me. The witness will have the exhibits before he or she, as will counsel. And they have been very cooperative in letting each other know what exhibits are going to be used with a particular witness. So the hearings that I have had have not been particularly difficult at all. The witness will be on the Zoom screen, of course. I have the authority to administer the oath, which I do. You know, there'll be a split screen like we have today. The examining lawyer will ask the questions. The exhibits have been pre-marked, and it's been very smooth. Now, you know, I can foresee a lot of instances where there'll be authentication issues and all kinds of things that may be more difficult to deal with on Zoom. But so far in the limited hearings I've had, the lawyers have been prepared. The exhibits have been stipulated to for the most part, and the witness has had the exhibit in front of them while the examining attorney is proceeding. So we do the direct, obviously. We proceed to cross. We proceed to redirect. I ask whatever questions that I may have, and then we proceeded to the next witness, and it worked very smoothly. Now, I did have a sequestration issue because, you know, I had a case where there were other witnesses and they wanted to hear, and there was a dispute over whether they were corporate representatives or entitled to be an exception to the sequestration rule. So I've had to deal with that a couple of times, and we just broke those witnesses out. And at one point, you know, we didn't even want to really break them out. We wanted to kind of like have them disconnect from Zoom. And then the lawyer called them when it was their turn to testify, and they would hook back onto the Zoom meeting, and then they would offer their testimony. And after that, they were free to stay on the conference. But it's, you know, it's not the same. It's, you know, as Will said earlier, when you're in a courtroom, you get a different feel when somebody's actually in front of you. You just get a different perception. And it's, you know, it's not quite the same as having the witness right next to you testifying, with you having everybody, you know, having documents and being able to pass case law and things like that. It's not ideal, but, you know, during these times we have to sacrifice the perfect for the good, and it is good, and it works. And you know, it also forces lawyers to be, I find that it forces lawyers to be more direct and more economical in their presentations, because you have to use your time very wisely. You have the technology issues that you have to deal with. And, you know, I find in most cases, you know, especially in this division, most of them are overpled and overtried. And you can usually get to the nut of the issue much faster than many lawyers do. And Zoom has kind of forced people, in my opinion, to condense their presentations, pick their documents that they really need more carefully. and budget their time more efficiently. So in some ways, I have found that the hearings I have had have been faster, more efficient, and get more to the point because the Zoom platform kind of forces that dynamic. And so it's, you know, there's pros and cons like anything else. But like I said, I don't think any case, the result has been any different than it would have been in the courtroom, or the presentation has been materially different than it would have been in the courtroom. And you know, it's gone well so far.
Well, one of the issues, if I may, one of the issues that I found to be interesting, and it's come up a couple times, is during the evidentiary hearings that I was having, the lawyer made the request that I instruct all the witnesses as well as all counsel that they are not to communicate with the witness through text messages or through any type of, if they're all in the same room, or if they somehow could send each other communications. And at one point, a lawyer asked that the witness who was on his laptop stand up and show who else was in the room with him, because they were concerned that they had local counsel who may be there, who may be coaching them. And so I guess some of the concerns that Zoom creates is that you don't know, like right now, I have my laptop here, and I have my phone right next to me. And there's anything stopping. Like Michael just sent me a message telling me he thinks that this was such an excellent idea for us to have this Zoom meeting. And if that wasn't true, but if that was true, he could send that to me and we could communicate, and you all would be none the wiser that Michael had just sent me that communication. And so that's part of the concern that some lawyers have raised. I think it's been unfounded because, as Michael said, I think we're dealing with professional people, and I don't think people are willing to jeopardize their case, nor are they willing to jeopardize their reputations for such unnecessary coaching. But it's been issues brought up in 2 evidentiary hearings that I've had. The other thing that I think is interesting is that I require them to upload all the exhibits pre-marked in a PDF document, and to serve it upon all the parties so that we are all dealing with the same documents. But I don't physically have the documents, meaning that I don't have the notebook. I'm actually looking on screen at whatever documents are going to be used during the proceeding. And again, this screen share is such an excellent tool, because it has saved the need for me to physically have the document, because the lawyer will basically say, Judge, this is Exhibit A, and can you see it? Yes, I can see it. He points exactly, the witness can point exactly to the section that they want the court to reference, and it's just been excellent. But other than that, and sequestration, the same thing as Michael. I had a little stumbling with this, and I'm glad Michael did the same thing I did. I just basically asked the witness to basically log off, and then we would simply, they had the contact number for the witness, and whenever they wanted to call the witness, they would just simply send a message to ask the witness to log back onto the system, and then my assistant obviously can monitor. That's another reason, by the way, for monitoring to see who's all on the line, is that we all know who's on the line, and their numbers are there, and we can verify that it is truly a sequestrated hearing. So that's the way basically we've dealt with it.
And Judge Thomas, I believe you indicated earlier that you keep everyone on mute except for the person who are speaking. So in an examination situation where the witness and the 2 attorneys need to be able to speak, is everybody off mute at that point?
Yeah, in fact, what we do is because there could be other people in the hearing, they have to, because people have to object, people have to. And so during the evidentiary hearing of it, we don't use that same process, because really you can't, because you can't stymie, you can't retard the proceedings by having people waving their hands saying, Judge, I need to lodge an objection.
And so to that point, have you had an opportunity to deal with any bench conferences on objections where the witness needs to be silenced or muted or not able to hear the proceedings while that happens?
Not yet. And that's going to be challenging because I'm not sure exactly what we would ask of them to do. I haven't had it yet. Michael, have you had that? I'm curious.
Yes, I had it in one instance. And what the lawyer who was hosting the meeting was able to do is make a side meeting for just me and counsel. In other words, we went into like a separate Zoom room with the court reporter, and the objection was argued. I ruled. Then we went back into the primary Zoom conference and continued the hearing. But I only had one sidebar. I've had one sidebar. I've had 3 evidentiary hearings, and I've only had to have one sidebar.
That's interesting. So
very unusual. But
so from my experience, you can only host or run one Zoom meeting at a time through your account. So perhaps a good practice tip would be, for example, if plaintiff's counsel has arranged for the meeting, that defense counsel be prepared to set up a Zoom room for the judge and the 2 attorneys to jump in the event that there is a conference that needs to be had outside of the presence of a witness.
yeah, I know it's not difficult because, for example, and I don't know if we're going to talk about this, but the mediators I routinely assign cases to that are very, very sophisticated commercial mediators have been doing their mediations by Zoom. And they have breakout rooms, which are necessary in the mediation context. So they have found it to be extremely efficient. They break out with parties in a breakout room. Other parties are on the conference and can go about their business or do whatever they're doing. So I guess what happened in my evidentiary hearings is that the parties just had the ability to do breakout rooms. Now, like I said, I'm not the technology guy. I don't know how they did it, but it wasn't hard. All of a sudden, it was kind of a different room on the screen, and I was there with just the 2 lawyers and the court reporter. And then when it went back, we had the witness back on the screen, and we proceeded along without any difficulty.
Judge Thomas, you mentioned a moment ago that the screen sharing feature has been very effective in your estimation for the purpose of introducing exhibits, using exhibits during the hearing. I was wondering if you could give us a brief description of how exhibits have been authenticated and introduced into evidence. It sounds to me like a lot of this has been done in advance via stipulation, and perhaps the technology is forcing the attorneys to, engage in even further agreements than previous.
Well, yeah, and in fact, this is, again, why you appreciate the professionalism of the lawyers. A lot of this has been worked out prior to the evidentiary hearing beginning, and even before the evidentiary hearing begins, if there's an issue with an exhibit, we discuss it and resolve it before the hearing begins so that we don't have these issues in the middle of the hearing. But I haven't had any instance as it relates to authentication of documents or the use of a document where there has been an objection where the document has not been able to be used based upon authentication issues. And I credit the lawyers for that, and I thank them for that, because I think everybody's understanding that we're in a unique situation, and we all have to still zealously advocate on behalf of clients, but not unreasonably obstruct the orderly process that we all are forced to labor under.
Thank you. We have a number of audience questions, some of which relate to exhibits and witnesses. We'll see if we have time at the end, but for now I'm going to hand over to Allison for a discussion of professionalism and etiquette.
Thanks, Keith. So just before we get to that topic, judges, I had a question. Are you having any in-person proceedings whatsoever? Just to be clear.
No.
Okay. So
No.
There was mention in one of these meetings with the bench and the bar about, this was a suggestion, I don't know that it was actually implemented, but about having a bench trial where some of the key witnesses appeared in person, and you heard testimony in that way, or the judges would hear testimony in that way in a socially distant manner, and then have the remainder of the proceedings by Zoom, the expert witnesses or other lesser important witnesses. What are your thoughts on a format like that?
Well, right now it's not feasible because the courtroom's closed.
Okay.
And I don't know when we'll be open. I'm not really a fan of having like a truncated, bifurcated procedure like that where I hear some witnesses live and others. I mean, if we get to the point where the courtrooms are open and social distancing protocol is put into place and we're permitted to have our evidentiary hearings in court, that's probably where I'm going to be. And until that time, we're going to have our hearings by Zoom, but I can't really envision a situation where I would say, I'm going to hear some witnesses in court and I'm going to adjourn the hearing. We're going to get on a computer. I'm going to hear other witnesses on the computer. I don't know what that adds to the equation. If we're capable of doing it in court safely and, the administration is open, the courthouse and the county is, and the mental, the health professionals have given us clearance to do proper social distancing and be back in court, that's probably where I'm going to be conducting hearings.
And Allison, I think that the beauty of the recognition that judges and lawyers are just like everybody else within this community is as evident as it could ever be, because I'm a single dad and I have a 9-year-old. And what do I do with my 9-year-old who is not in school? There are no daycares. If in fact I have to go to the courthouse and actually conduct partial hearings and also do partial hearings through Zoom. And I know I'm not the only one. There are a lot of parents in the same situation. And that's why the beauty of Zoom is so much appreciated, because it takes the stress away from not just the judge, but also the lawyer who has to tend to these other obligations that it really does play on. It preoccupies your thoughts. I need to make sure, like right now he's on Fortnite and I let him stay on Fortnite because he won't interrupt what I'm doing right now. And I know he can do that for an hour easily. But he can't stay on Fortnite for too much longer. And so I'm not a fan of rushing back into a situation that creates a level of anxiety on the parties and the court that is just simply not in the best interest of the litigation going forward.
Sure. Okay, so Judge Hansman, I noticed on your courtroom procedures, you say that casual attire is encouraged. What do you mean by that?
Well, I just don't see a need. I don't see a need to make lawyers get dressed up and put on suits and formal attire to sit in their family room and talk to me about, the economic loss rule. You know what I mean? I don't see any reason for that. I try to come generally casual. I'll typically be wearing my black sweater, which kind of robish, but I don't get hung up on that. I mean, there has to be a level of decorum. I don't expect lawyers to show up in, tank tops and sleeveless, shirt, like t-shirts, but, a nice pullover or a nice shirt with, I don't see the need to put suits and ties and get all dressed up for one hearing and then have to go get, you're in your home. So I have no problem with casual attire. Now, if we get to the point where there are trials and there are witnesses and things like that, maybe we'll change protocol. But right now, 95% of what I'm doing is just legal argument with the lawyers. I don't really have, yes, we have corporate representatives on a couple of these, status conferences and case management conferences, but it's a strange time. People are home with their children. They're in their homes. They're taking care of personal things, well, professional things. So I just, I think it's fine. Just come on casually and argue your motion and then go about your day, which is exactly what I do.
Judge Thomas, any comments on that?
Well, I'm much more formal. I put on the robe every single time I'm in the hearing, and I don't require lawyers to be in a suit. But it would be nice if they had on a dress shirt with a jacket. I mean, I'm not going to tell you what I have on under this robe, but I do have the robe on, and I don't think it's a stretch to just put on a dress shirt and a jacket. it just can be easily taken off. And the reason is because I believe when you look the part, you act the part. And I think when you're a little too casual, sometimes you may forget where you are. And I just think it just helps. Even though I haven't had an issue, I just think it helps. And I've never called anybody out. I think there was one person who did have a t-shirt on, and I did say to the person, you notice I have my robe on. Could you please just have a shirt and a jacket on? You don't have to have a tie, but at least a shirt and a jacket on. And he said, no problem, Judge. And I think that was the one instance where it was mentioned. But again, there wasn't a big deal made out of it.
Okay. So Keith, let's go ahead and skip to those last three questions we have, and then let's get to some audience questions, because I see we have only about 5 minutes left.
Sure. Judge Hansman, I believe earlier you indicated that you were very enthusiastic about the Zoom platform. Do you expect this to be here to stay long-term, irrespective of how this pandemic situation plays out, as people become more familiar with it and the court becomes more capable in this regard?
You know, it's going to be very interesting to see how that develops. You know, I'm of two schools of thought on that. I'm kind of a traditionalist. I like the courtroom. I like having people in front of me. I like being able to see people. I like being able to hand me a document or hand me a case. And I'm very traditional in that regard. But at the same time, you know, the law, like a lot of other professions and businesses, seems to not really adapt to change quickly. We kind of work at a glacial pace as far as adopting technology, you know, which is, you know, changing doctrines that may be antiquated. You know, it takes, just like it takes a long time for substantive areas of law to sometimes change that should be able to be changed much quicker. It takes a really long time for the legal profession and the judiciary to adjust to technological changes. So, you know, I would like to think that because it's very efficient, lawyers don't have to pay and charge clients for travel time and sit in the courtroom for 2 hours while they wait for their case to be called. I would like to think that this technology would stay around and be subject to use when appropriate. But, you know, I kind of think human nature being what it is that assuming there's no health issue, things will probably go back to business as usual. Now, having said that, I'm going to be open-minded when this is over, God willing, that it ends at some point, to conducting hearings remotely if there's a reason to do it. I mean, lawyers are out of town, witnesses, you know, can testify remotely. It seems like we have a lot of inefficiencies in the law. You know, people travel for depositions to go across the country for a 3-hour deposition. So having experienced this now, I think I'm going to be much more amenable to using technology in cases, whether it be depositions, whether it be a witness who may be out of state but needs to testify in a trial. And I'm going to encourage lawyers to do the same, because I think it just makes the practice more efficient. It allows clients to save a lot of money. And if I have one hearing during a day, and that would be the only reason I'm going downtown, and the lawyers want to do it by Zoom, I'm going to be much more amenable to that. But generally speaking, I joke that I may never go back to the courtroom. Generally speaking, at the trial court level, I think that being physically together has a lot of benefits.
Thank you. We're running up on the end of the hour, and we have several audience questions that we'd like to get to. And so I'll pass to Allison for the first one of those.
Okay, so one of the first questions is, can the parties agree to record via Zoom and then send to the court reporter only if a transcript is necessary, rather than have the court reporter on the Zoom meeting?
I don't know. I don't get involved in that. You know, I don't, you know, whether to have a court reporter at all is up to the parties. Now, whether or not that would be a legal transcript in the event of an appeal or something of that nature, I don't know. I don't know whether that would be recognized as a valid transcript.
In fact, I think there was an administrative order that was put out by the chief judge that speaks to that issue. And my position is no. If you have a court reporter, the court reporter is the official transcript and should be the only recording of the proceeding. And I mean, that's just my position if I was asked. And to be honest with you, if I was made aware that someone recorded the proceedings without notifying the court that they recorded the proceedings, I would have a problem with that.
Okay, how are the courts handling the admission of original documents into evidence, for example, a promissory note?
Michael, I mean, I'm curious as to what you've done, because I'm keeping a list of final judgments that I've signed, and so that I'll go back to know that I need to capture those, cancel out those promissory notes. But I don't know I don't know how that's being handled, aside from the fact that keeping a list so that it can be canceled, because they can send them to me. But to be honest with you, you know, my bailiff goes down to the office twice a week to go through things. But I don't, Michael?
Yeah, I've had a couple. First of all, the foreclosures are kind of dead right now. I'm not really doing foreclosure trials. So I haven't had those original negotiable instrument type issues. But I know that some of the judges who've done them that I've spoken to have had the originals maintained in the possession of counsel and then delivered to the clerk's office post-judgment.
Post-judgment.
So they can get the stamps and all the things taken care of. When I did my evidentiary hearings, what I did is we agreed to proceed with counsel maintaining the original exhibits, and then once they were introduced, they kind of put an exhibit binder together of matters that were introduced into evidence, and then it was delivered to the clerk's office subsequent to the hearing. But I don't take original documents. I don't take them in chambers. So the way I have done it is the parties have maintained control over that until the hearing is concluded, at which point they get delivered to the clerk's office, and my clerk, who's going downtown a couple days a week, will take the exhibits in and have them appropriately docketed. But that's been a little bit of an issue. You know, I've had a couple things that have been filed that I've been unaware of, you know, because these things aren't being docketed quite as fast as they normally would. And it's really not my habit to go look at docket sheets. So, you know, a couple times we've had people file things and they haven't been docketed for a couple of weeks. So if you file something, you should not presume that the court or chamber is aware of that. So if you file something that needs attention, or you file something that must be ruled on before any other matters can be heard, for example, a motion for disqualification, something like that that has urgency, I think it should be incumbent upon lawyers to notify chambers that this thing has been filed and it needs attention, because you can't presume that we're sitting around the computer terminal logging into the clerk's office to see what are filed in our hundreds of cases, because we're not.
Okay, so I'm going to collapse a couple questions here. We have a number of questions on exhibits. Do the judges prefer screen sharing or reviewing previously provided exhibits when evidence is introduced? And also, if you are screen sharing, does that detract in any way from being able to assess the witness's credibility while they are testifying about a document?
I prefer screen sharing, and I don't think you keep the screen sharing up. Like I've said to the lawyer, are you done with that document? And can you take the screen sharing down? Because obviously you want to see the person who's testifying. And so it has not been a distraction, and it's worked really, really well. And I do prefer screen sharing.
I do as well. You know, it's been nice because people just put the document up on the screen while the witness is testifying, and it's worked well. As far as the second part of your question, I haven't really found that having somebody testify in front of me by Zoom has significantly impaired my ability to assess credibility and things of that nature. But again, it's not the same as having the person sitting next to you in the courtroom. It's not the same. But can I say that it's been outcome determinative in any case or any issue? No, it is not. But it's better to be in the courtroom, in my opinion.
Okay. Then I have one last question from Brian Spector. he asks, can Judge Hansman explain in less than 20 words the difference between loss causation and transaction causation? And he would like for you to use monosyllabic words only, please.
I'm going to have to demur on that because I could never explain the difference between those two very complex concepts in under 20 words. In fact, I think it's taken me more than 20 words to say that I can't.
Okay, so thank you so much to our judges, Judge Hanson and Judge Thomas, for joining us. This is very valuable. Before we conclude, are there any general practice tips, anything you haven't mentioned that you'd like to share today about virtual practice?
The only thing I would say is, I think it makes your paper filings even more important. They're always important in this division, but getting your points across in your briefs and making sure we have the case law put into the supporting document screen is really important, because in my hearings, I have the lawyers upload all the briefs and case law in the supporting document category under the MAP system. And that's what I'm looking at before the hearing. And like I said earlier, it's very hard. I like to have lawyers pass me highlighted copies. I'll read the case. I'll interact with them. We don't have that ability by Zoom. So it's very important that your briefs really cover the points, and the case law, your primary authorities, be uploaded so they can be read on the computer before the hearing. Because like I said, you don't have the ability to, Judge, can I hand you this case out of the 3rd District that was decided last year, and let's just interact and talk about it. And it's more difficult. So your papers, getting it right in the briefs is really important.
I would agree with Michael, and I would also add that it's equally as important. I have my judicial assistant go through and pull all of the motions, the response and the reply. But if there's a case that you're going to be relying upon, it would be nice if that case was also uploaded as part of your brief, so that the court can review it rather than the court having to go and look for it. That, I think, is a practice tip, because lawyers have cited cases that they cite in their brief and they start reciting what the case stands for. And then I have to write down the site and now go look at that, pull that case and read that case to see whether or not I want to follow that law. But if you had already had it attached, I would have been able to have a conversation with you about the facts and so forth. And so I think it's because of where we at. Normally I wouldn't even require that. I would just go and do it myself. But under the circumstances, I think that it's a better practice to have a case that you're relying upon also uploaded and attached. And I just don't think that we're ever going to go back to the normal courtrooms 100% the way it is. And I think this is going to start being part of our new normal, and I think we all need to get used to it.
Okay. All right. Anything else, Keith?
No, that's it. Thank you, judges. Thank you, Allison.
Thank you all
for joining. Stephanie, would you mind just uploading the or sharing the course number one last time with the attendees and the panelists, please?
Of course. The course number is 3969, title A View from the Bench, Virtual Practice in Business. And it sometimes will be about 24 hours before you can actually self-report that. I know I had that happen yesterday. So if you can wait until either tomorrow or possibly Monday just to self-report, that would be fantastic.
Okay, great. And so you'll be, we've had over 140 attendees at this event today at one point. So thank you so much, judges, for your time and for your willingness to accept this technology and implement it.
Allison, this was a great idea, and we thank you for the insight of putting this together. I think this was great, and hopefully we'll have an opportunity to do it again.
Sure.
Agreed. Thank you again, guys.
Bye-bye.
All right, bye-bye.
Stay safe.